program. We'll see that as part of the Farm Bill that the Senate will be working on. Alan Bierga, Bloomberg News reporter, thanks so much for being here.
Thank you.
We go live now to the U.S. Senate, opening the day with general speeches. They'll be working on the Farm Bill at 3 p.m. Eastern, and later today, debate on 2 judicial nominations, with votes starting at 5:30 p.m.
The Senate will come to order. The chaplain, Dr. Barry Black, will now lead the Senate in prayer.
Let us pray. Eternal Lord God, because you are our shepherd, we face the future with confidence. Keep our senators humble as they seek to serve you and country. May they never forget your kindness to them and this land we love. Remind them that you alone are the source of their strength and the shelter where they can find safety. Listen to their prayers and answer them, supplying all their needs according to the richness of your grace and mercy. Lord, strengthen them for each challenge as you bless them in their going out and coming in. May they overcome cynicism with civility in all their relationships. We pray in your gracious name. Amen.
Please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The clerk will read a communication to the Senate.
Washington, D.C., May 20th, 2013. To the Senate. Under the provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Tim Kaine, a senator from the Commonwealth of Virginia, to perform the duties of the chair. Signed, Patrick J. Leahy, President Pro Tempore.
Mr. President.
Majority Leader.
Following leader remarks, the Senate will be in a period of morning business until 3 o'clock today. At 3 p.m., the Senate will begin consideration of S. 954, which is the Farm Bill. At 5 p.m., the Senate will proceed to executive session to consider 2 United States District Court nominations, the Chappell nomination from Florida and the McShane nomination from Oregon. At about 5:30, then, there will be up to 2 roll call votes on confirmation of these nominations. Mr. President, Democrats and the Tea Party-driven Republicans disagree on many things. So it's really remarkable and encouraging to see how well Senator Stabenow and Senator Cochran, the chairman and ranking members of the Senate Agriculture Committee, worked as a team to bring the agricultural jobs bill to the floor. Their work has been exemplary. Some would say old-fashioned, the way things used to be. The committee even included many of the amendments that were adopted last year when the Senate considered and passed a farm bill. As we'll remember, it went to the House, and of course they did nothing. The committee did this in an effort to expedite the floor process, which begins today. I hope their cooperative spirit guides our work on this important legislation. American farmers are counting on us, but so is the economy. Despite the uncertain economic times, America's farms and ranches are the most productive in the world, exporting about $150 billion worth of products last year and supporting 16 million private sector jobs. But to keep American farms strong, Congress must pass a strong farm bill. The legislation before this body will create jobs, cut taxpayer subsidies, and reduce the deficit. The bill includes important reforms to farm and food stamp programs. It saves more than $23 billion, which will be used to reduce the deficit. And it will give farmers the certainty they need to maintain the largest trade surplus of any sector of our economy. Helping American farmers thrive is an important part of our work to get the economy on firm footing again. Again, I commend Senator Stabenow and Cochran for the leadership on this important issue. On another subject, Mr. President, while the Senate has taken laudable bipartisan action on the agriculture jobs bill, it has seen no progress on the important budget. Senate Republicans still refuse to allow us to negotiate with our House counterparts a compromise that respects both parties' principles. Mr. President, it's now been 58 days since the Senate passed its budget. 58 days waiting for the Republicans to say, okay, let's try to work out our differences. They've been talking for a couple of years now. What's wrong with the Senate? We don't follow regular order. What does that mean? We don't follow the principles we've always followed. And they've said, we want to pass a budget so we can get to regular order. I guess they thought we couldn't pass a budget because we passed one. Now they refuse to go to conference. I think the main reason, Mr. President, they're afraid to do that, under the rules in the House, that if we go to conference, the House Democrats, which are kept out of everything, have the right by rule of the House Representatives to offer what they call motions to instruct, to say don't cut Medicare, don't whack little kids that are trying to get an education with the Head Start program, don't cut the NIH programs, and they can force the Republicans to vote on that matter. So I think that's what it's all about. So it's been 58 days since the Senate passed its common sense pro-growth budget. But my Republican colleagues have objected time and time again to a conference with the House. The only explanation Republicans have given for the endless obstruction is this. They refuse to negotiate unless we agree in advance to let them win. And I'm not making that up. That's true. Republicans refuse to go to conference unless Democrats adopt policies that were soundly rejected by the American people last November. It's a very bizarre way to negotiate. Meanwhile, the country inches closer and closer to yet another crisis, a default of the nation's legitimate bills. Republicans hope to put off compromise until the last moment so they can use the debt limit as a bargaining chip. They hope to extort concessions such as more tax breaks for the wealthy, hurting middle-class families, more concessions for draconian cuts to Medicare, which of course hurt the elderly, extort concessions with cuts to Head Start, hurting little kids, or they hope to extort concessions on more cuts to the National Institutes of Health, which hurts us all. In fact, House Republicans met last week to decide what ransom they would demand in exchange for agreeing to avoid a catastrophic default on this nation's debts. One House Republican called it a laundry list of conditions. On the list, repeating landmark health care reform. On the list, restricting women's health choices. On the list, more draconian cuts to programs that are keeping American families strong. Despite the political pain Republicans caused themselves last time they held hostage the full faith and credit of the United States, they're again headed down that same path. This time they're suggesting the government should skip payments to the troops, to veterans, to Medicare recipients, and more. Why? So we can pay China first. Mr. President, I'm not making this up. That's what they want to do. Their plan would hurt our national security, our economic security, and it wouldn't prevent default. The Republican approach to default on the bills is irresponsible, extreme, and really senseless. By now, they should know that it's compromise, not political hostage-taking, that will set our nation on the road to fiscal responsibility. Would the Chair announce the business of the day?
Under the previous order, the leadership time is reserved, and under the previous order, the Senate will be in a period of morning business until 3 p.m., with senators permitted to speak therein for up to 10 minutes each.
I would note the absent quorum.
The clerk will call the roll.
Mr. Alexander.
Consent.
And in a quorum call here on the Senate floor, waiting for senators to come to the floor. And today here in the Senate, they'll be working on the Farm Bill, expecting that work to start up at about 3 p.m. Eastern Time. And later today, debate on 2 judicial nominations, votes on those nominations starting at 5:30. While we're in the quorum call, we're going to take you to the Senate markup of the immigration bill, which is going on right now.
And consular officers. When making admissibility decisions, our frontline officials need tools at their disposal that let them analyze potential threats. My amendment would simply state that profiling based upon country of origin is not prohibited by a ban on racial profiling. It does not require that the country of origin be used as a basis for limiting admissions. It simply states that nothing in the bill prohibits it. So don't read something into this amendment that it doesn't do. In fact, when addressing the 5 nominees for the Privacy and Civil Liberties Oversight Board at nomination hearing last year, I asked all the nominees whether country of origin can be used to profile. Now, out of those 5 nominees, 4 of them, for the board, agreed that country of origin can be utilized as a basis to scrutinize entry into our country. These 4 argued that nothing in the law or the Constitution prohibits it. They argued that nothing, the amendment ensures that the status quo is not changed. So I urge my colleagues to support what I think is a simple amendment connected with national security, used for other reasons. Why isn't it used for this legislation?
Mr. Chairman, thank you very much. Senator Grassley, let me say 2 or 3 things about this. First, there is no mention of country of origin in the language of this bill. We specifically do not mention country of origin, and that was the basis of your argument. And so I'd ask you and your staff to take another look at it. We do not raise that issue. Number 2, the language we...
Can I ask you a question at that point, please?
Sure, of course.
Why then don't you mention it as so that it's...
Because what we've done is to specify that you cannot use race or ethnicity. Now, how did we come up with race or ethnicity? This was the standard established...
I'm not arguing that point. I think you're right by including that in the bill. But what does country of origin have to do with anything of profiling?
It's not mentioned in here, nor is religion mentioned in here. I mean, there are a lot of things we could have mentioned. Why did we pick race and ethnicity? Those were the standards established by Attorney General John Ashcroft in 2003. We took the Ashcroft profiling guidance issued by his Department of Justice and embodied it in this. It is not a radical departure from past practice. In fact, it embodies the practice of a former conservative Republican Attorney General under a Republican president. Why do we even care about this? You and I see one another a lot in Washington, but we also see one another a lot at O'Hare International Airport. We spend a lot of time together in airplanes, traveling back and forth to the Midwest.
Lucky guys.
Lucky guys that we are. And so it was about 15 years ago that I got a complaint. Well, it actually came as a result of an investigation by a Chicago television station. This one woman complained that she had gone through O'Hare when she came into this country and was strip searched. And she was so embarrassed by it, she reached out to a television newswoman who put the story on the air. Why was this woman, African-American woman, strip searched? And it turned out that as a result of that story going on the air, women started calling this reporter from all across Chicago, saying it happened to me too. It turned out, when we did the investigation on this in 1998, African women were being profiled by the Customs Service. The GAOs did a finding on it, an investigation. African Americans were twice as likely, 9 times as likely, and Hispanic Americans were nearly 4 times as likely as white passengers to be strip searched. And there was no evidence of contraband in those groups that were being strip searched. This was clearly a waste of effort and an embarrassing and insulting exercise of authority. Having said that, let me be the first to say the men and women in law enforcement, including our customs agents, are good, well-intentioned, patriotic people. Occasionally mistakes are made. So we took the Ashcroft language, which strictly limits it to race and ethnicity, and made some specific exceptions, and it does not go to country of origin, which was the basis of your argument for your amendment.
If you want me to close, I'll close. Does anybody else want to speak?
Briefly, Mr. Chairman, if there were information that you had, let's say, a small group of persons from a small country in the United States that are involved in moving heroin, would that not be something that you could identify?
Senator from Illinois.
Please. I just don't know what the language is.
Respond to the senator from Alabama. He's right. And the language says federal law enforcement officers may not use race or ethnicity to any degree, except that officers may rely on race and ethnicity if a specific suspect description exists.
Okay.
So
well, if you can rely on race and ethnicity, why wouldn't country of origin be?
I don't know why. I don't know why the argument's being made that country of origin should be included. Is that what you're arguing?
Yeah, like Senator Grassley suggested.
Well, because Attorney General Ashcroft and others happen to believe that was a waste of time to say that everybody who comes to this country from one other country is going to be subject to a special search. It's a profiling effort which doesn't really make us any safer.
I would just say this to my good friend who's an excellent lawyer and experienced in these matters and cares about them deeply. I'm worried about some of the language there. Some of it is exactly the same as Department of Justice guidelines. So some might say that's not wrong, so that's okay. Why wouldn't we put it in law? But there are others, such as terrorist investigations, that say an investigator has the full constitutional powers that you would normally expect.
So ordered.
Mr. President, I have one unanimous consent request for a committee to meet during today's session of the Senate. Has the approval of the majority and minority leaders. I ask unanimous consent that this request be agreed to and that this request be printed in the record.
Without objection, so ordered.
Mr. President, I'm pleased that today the Senate will be voting on the confirmation of Judge Michael McShane to serve as U.S. District Court Judge for the District of Oregon. Judge McShane is a product of the Judicial Selection Committee that I've organized at home in Oregon. Senator Merkley has been in full support of this effort, and Judge McShane is coming forward for consideration by the Senate as a result of the work of that Special Judicial Selection Committee made up of individuals of a variety of different philosophical views. And I'm very pleased that the President has seen fit to send Judge McShane's name to the United States Senate. Now, in a sentence, Mr. President, Judge McShane has a heart for people, a head for the law, and a high-minded sense of justice. I'd start by way of saying he certainly has outstanding academic credentials. A magna cum laude graduate from Gonzaga University. He attended the Northwest School of Law at Lewis and Clark College, where he graduated in the top 10% of his class. And his accomplishments in the courtroom have earned him very high ratings by the American Bar Association. So from an academic standpoint, Judge McShane is clearly qualified for this position. But what I feel particularly strongly about, and what was evidently very important to our Judicial Selection Committee, is that he has been an extraordinary member of our community, always stepping up, particularly when someone called to ask him to be an advocate for youngsters, and particularly inner-city youth, HIV-positive youngsters. In these various leadership and volunteer roles, he has always come forward not just to help, but also to come up with innovative approaches in terms of his work with kids. You see this in his advocacy for at-risk youngsters in the Job Corps program especially. Judge McShane brings these young people into his courtroom as interns to help with the day-to-day operations where they're given the opportunity to see the inner workings of our judicial system. In many instances, Mr. President, Judge McShane literally guides them through the process and sets about to make it possible for them to be involved in ways that you normally wouldn't think of when you're looking at the role of a judge. For example, in many cases, Judge McShane buys sport coats and khakis for these youngsters who would otherwise feel, if they were going to be thrust into a courtroom, that they would be uncomfortable from the moment they set foot in the court. And so Judge McShane says, I want to make sure that those young people have a chance to blossom. Those are the words that he uses, Mr. President. So he makes it possible for them to get the sport coats and the khakis with his own money so they can participate in this unique training. This past year, he was awarded the 2012 Oregon State Bar President's Public Service Award for his service to the community. And he's involved in the Northwestern School of Law's mentoring program, and in 2009 was named the law school's Mentor of the Year. Also, through the Classroom Law Project, Judge McShane provides over summer law camp for inner-city kids. And on top of that, Judge McShane plays an important role as a foster and now adoptive parent through the Oregon Department of Human Services. So you look at that kind of community caring, Mr. President, and you say this is truly an exceptional individual. And then what we did is juxtapose that wonderful record of community service alongside his legal track record. Judge McShane began his legal career as an attorney with the Metropolitan Public Defender's Office in Portland. I think we all understand how important public defenders are. And as a result of his good work there, in 1997 he was appointed by the Oregon Supreme Court as a full-time pro tem judge. For the last decade, he's been an adjunct professor at his alma mater, the Northwestern School of Law at Lewis and Clark College, where he teaches trial advocacy and the criminal practice seminar. Now, again, going back to why I believe he is academically and professionally very qualified to be a judge, his litigation experience includes both complex criminal and civil cases. He is the senior member of Multnomah County Circuit Court Death Penalty Project, and he has presided over more capital cases than any other sitting judge in our state. He's been a proven advocate for evidence-based sentencing, and he's created a proof-based sentencing model for driving under the influence of intoxicant offenders that now has become the standard in Multnomah County. So, Mr. President, it is for all of those reasons, especially his track record in terms of community service, but also those outstanding professional experiences, starting as a public defender, teaching in the classroom, that I am very hopeful that the Senate will agree with me on a bipartisan basis that Judge McShane is qualified to serve as the U.S. District Court Judge for the District of Oregon. As I indicated, a heart for people, a head for the law, a high-minded sense of justice. We have a long history in our state. I think the President of the Senate is aware of some of those who have been part of our network of distinguished judges, and I have, Mr. President, every confidence that Judge McShane will join that list. I thank Senate Judiciary Committee Chairman Leahy, and Ranking Member Grassley for advancing Judge McShane's confirmation through the committee. I also want to thank Leader Reid and Minority Leader McConnell for bringing this nomination to the floor, and I look forward to the vote that we'll have later today, and I hope my colleagues on a bipartisan basis will vote to confirm Judge Michael McShane as U.S. District Court Judge for the District of Oregon. Mr. President, with that, I yield the floor, and I note the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
In a quorum call here on the Senate floor, waiting for senators to come to the floor. And today they'll be working on the Farm Bill, 3 o'clock p.m. Eastern Time. Later, also debate on 2 judicial nominations, with votes on those nominations starting at 5:30 p.m. Eastern. And while we're in the quorum call, we're going to take you to the Senate markup that's going on right now of the immigration bill.
Convicted drug trafficker, then both a drug trafficker and a gang member. So as currently written, why would this provision ever be used? Simply put, I don't think it would ever be used. My amendment then strikes this do-nothing provision and issues a new, clear, simple standard to address the problem of gang members. My amendment, the Secretary of Homeland Security must prove, number 1, criminal street gang membership. Number 2, that the person is a danger to the community. Once the Secretary proves these 2 things, the burden shifts to the foreign national to prove that he is either not dangerous, not in a street gang, or did not know that the group was a street gang. It is straightforward and will help remove dangerous criminal gang members. My amendment also eliminates the possibility of a waiver. So I urge my colleagues to adopt this amendment and provide real measures to remove foreign national criminal gang members from America. I yield the floor.
I'll yield to one of our most distinguished gang members, gang member from Illinois, Gang of 8, Senator Durbin.
Thank you very much, Mr. Chairman. As we're thinking about tattoos, but I don't want to make lightly of the subject matter here. I don't want to know. Let me say at the outset, Senator Grassley, gang activity is deadly and dangerous. There isn't a day that goes by in a major city in America when gang activity is not evidenced by shootings, killings, awful things which are occurring in my state, perhaps even in yours, certainly in California. So what I'm about to say here should in no way diminish the seriousness of the subject that you are trying to address in this amendment. And let me tell you what our bill says. We have strong standards to make certain that gang members are inadmissible, deportable, and ineligible for this legal status, RPI status. But we do it in a way that establishes 2 standards. First, knowledge, so that you know that you are part of a gang activity, and second, action in furtherance of the goals of that gang. The 2 basics knowledge, and action. Yours amendment does not address it in this manner. I looked at it, I just read through trying to find out what your standard was to establish that a person is a member of a gang. Your standard is a declaration. Any alien is inadmissible who is a member of a criminal gang. But you don't define what that means. We define it. You don't define it. And the difficulty is, once you have this undefined standard about membership in a gang, you shift the burden. Unlike most criminal cases where there is a burden of presumption of innocence, you shift the burden and say, once we've established you're a member of a criminal gang, you have to prove that by clear and convincing evidence you're not. So I think our standard is a more credible one, a more defensible one. And going back to the premise, I couldn't agree with you more on the deadly, dangerous aspect of these criminal gangs. That's why our bill takes it very seriously and spells it out in a way that is fair. Question was asked by one of my colleagues here. So what if someone at the age of 12 got a gang tattoo, but they haven't been actively involved in the gang? They decided they didn't want to be part of it for whatever reason it might be. Would you establish, based on your amendment, that that person is a member of the gang because they have that tattoo, simply by virtue of the tattoo? That, I don't think, is a fair standard. So I respect the seriousness of the amendment. I urge my colleagues to stand by the bill. I think the bill is much clearer and with very strong language. We do not want gang members as part of this bill when it comes to legalizing them and allowing them to stay in the United States.
Mr. Chairman.
Chairman.
Senator from California.
Well, Mr. Chairman, I hate to say it, but California has been the source state of gangs, beginning with the Crips and Bloods going way, way back. And the last time I looked, there were something like 160,000 gang members that were spawned out of that. So this is a big issue. I was just reading the bill language, and I'd like to take a moment and read it because I think it's important. The first thing is inadmissibility. Aliens in criminal street gangs in general. Any alien is inadmissible. One who has been convicted of an offense for which an element was active participation in a criminal street gang. Good. Had knowledge that the gang members engaged or have engaged in a continuing series of offenses described in another section. 3, acted with the intention to promote or further the felonious activities of the criminal street gang or maintain or increase his or her position in the gang. Who is 18 years of older, who is physically present outside the United States when the Secretary determines by clear and convincing evidence, et cetera, that he's willingly participated in a criminal street gang. And then there's a waiver for the Secretary. Then there's a section on grounds for deportation. Then there's aliens associated with criminal street gangs, ground of ineligibility for registered provisional immigrant status. Actually, the bill, Senator Grassley, is very good on this subject because we discussed your amendment over the lunch break because it's impossible for me to be for a bill that's going to allow street gang members the privilege that's inherent in some of these new rights we're granting. But I think the bill is rather comprehensive. I would be interested if anybody thinks anything is left out that should be.
I just wish, as I listen to this discussion of gangs, that the Senate had been willing to close the gun show loophole in the straw purchases of guns because so many of them go to gangs. But I guess we approach gangs, the problem of gangs in different ways, whether it's immigration or involving guns. The senator from Iowa has asked for a roll call.
I'd like to close if nobody else wants to speak.
I think others do want to speak, so
okay.
You want them to go first?
No, yes, please.
Senator Whitehouse and Senator Klobuchar.
I just want to speak briefly in opposition. I think that the notion of the ranking member's bill is a good one. My objections to it have more to do with how it would be implemented. I have worries that the determination of what's a gang and the determination of what's a member would be case by case, which I think would be highly inefficient and perhaps unfair. I'm not quite sure how the danger to the community determination gets arrived at, that I think is a reasonable standard. I think there's a, I guess I'd say I think there's a really good amendment in there, but I can't see how it works yet. And so perhaps I would offer to work with the distinguished ranking member on a bill that we could work on in a more bipartisan way on the floor. But at this point, because of what I don't understand in terms of its administrative complexity, I'm going to have to vote no. And I say that feeling very strongly about gang activity. When I was U.S. Attorney, we basically demolished the local Latin Kings organization, and 5 of them are still serving mandatory federal life sentences, and they're going to die in prison because of what they did. So I'm keenly aware of how much damage gangs do to our communities, but I'd really like to get this right and look forward to working with you.
Mr. Chairman. Like Sheldon Whitehouse, I also was prosecutor for 8 years, and I will never forget our case that we had where gang members shot through a house out on a shooting spree and killed a little 8-year-old girl that was doing nothing but sitting at her table doing her homework. And I would love to work with you on the language going forward. I don't think this quite gets at where we need to go in terms of the definitions. And I also appreciate all the work the Gang of 8 did in making sure that we made it very clear that gang members wouldn't come under any of these protections. But I think there could be more we could do, and I would love to work with you going forward, Senator Grassley.
Okay, I'll close then.
No, we still have more. Senator Grassley will give final word on his amendment. Before he does that, though, he said anybody else wants to be heard.
Yeah, I'll just
Senator
be brief.
Schumer?
I think both Senator Grassley's made good points, so have my colleagues from Rhode Island and Minnesota. And just speaking as a member of the gang, we're open to amendments and improvements on the floor. I think this could use some tightening up, but meeting people meeting in the middle on this or on the terrorism issues, on the all these other issues that we've talked about, we certainly don't think that this bill is perfect. We've worked hard on it, but it's always welcome to improvement on the floor, and I hope we could come together and move things a little further over on the gang language.
Mr. Chairman, briefly,
Senator Sessions, yes.
I think that Senator Grassley's amendment touches on an important point. I've always been a bit uneasy about convicting people of being a member of a gang. I mean, what kind of gang is it, as Senator Grassley asked? But we have that in law. As I understand your amendment, it basically says if you meet the standards for being convicted of a gang member, you also, therefore, would meet the standards of and being sent to jail for that. The government should use that as a basis to deny a path to citizenship for somebody illegally here that's in a gang. So I think that's a reasonable.
Well, actually, don't I understand the amendment is saying that they could be deported or denied RPA status without having been convicted of a crime?
Well,
see, that's my concern. I have
of a crime to be denied admission and legality in the United States if you've entered the country illegally. If the law is applied, you'd be deported flat out.
No,
but we're going to allow the people to stay, and then we're saying, but if you behave badly, such as being a member of a gang, you can't stay.
But what the bill says, if you're the bill has provisions making gang members inadmissible, deportable, and ineligible for registered.
You're right. I overstated,
Mr.
Chairman.
But this amendment goes further, allow them to be deported without even being convicted of a crime. I just have a certain visceral American feeling if we're saying that our laws reflect what's best in the United States. We do have the due process issue here. But Senator Grassley, you wanted to close, and then
yeah, I would like.
I'd
like to close with just a few points of rebuttal. First of all, I believe that what's in this legislation will be rarely used because it's written in a way that there are so many loopholes. And even if it is, the Secretary can still waive the deportation. And I would think that we would want to strengthen our laws in this area. The point was brought up about shifting the burden. The burden is shifted the same way as we do for terrorists. The government designates you as a terrorist. It's your job to prove that you aren't a terrorist. So that principle is not new with this legislation. And then several of my colleagues brought up that they aren't sure exactly how it works, that we haven't defined some things. We leave discretion to the Secretary, and you folks believe more than I do that the Secretary ought to have more discretion, but we don't change that discretion in this particular case. And if he's not a member of a gang, he has the opportunity to appealing to the Secretary, or if he doesn't get it there, he's got an opportunity to appeal to an immigration judge. I ask for a roll call vote.
Mrs. Feinstein? No. Mr. Schumer?
No.
Mr. Durkin? No. Mr. Whitehouse?
No.
Ms. Klobuchar? No. Mr. Franklin?
No.
Mr. Coons?
No.
Mr. Blumenthal?
No.
Ms. Hirono? No. Mr. Ratcliffe?
Aye.
Mr. Hatch?
Aye. By proxy.
Mr. Sessions? Aye. Mr. Graham?
Aye. By proxy.
Mr. Cornyn?
Aye.
Mr. Lee?
Aye.
Mr. Cruz?
Aye. By proxy.
Mr. Flake?
Aye.
Mr. Chairman?
No.
Mr. Chairman, the votes are 8 yeas, 10 nays.
Okay, Senator Whitehouse, you have yours number 5.
I do, Mr. Chairman. As the committee will recall, I had an amendment a little while ago that would try to protect an existing employee from being e-verified over and over and over and over again simply because ownership of the building that they worked in or the company that they worked in changed hands. And I was not yet at the stage where we had bipartisan support, and so I did not call up that amendment. Unfortunately, this amendment is in the same situation, which is to some degree astounding to me. We've had a considerable discussion about the need to protect this country from dangerous criminals and terrorists, and yet, if you want to buy a firearm in this country, the background check does not test whether or not you are on the terrorist watch list, i.e., people on the terrorist watch list are able legally to buy guns in this country. We can have our different views on a lot of gun issues, but I'm astounded that there's any divergence in views on whether or not people on the terrorist watch list should be allowed to buy guns in this country and not be headed off by the background check. So I had hoped that this would be fairly non-controversial, but apparently on the other side of the aisle it is indeed quite controversial, and I guess people are in favor of that, although I still can't understand why. So
in fact, that the Senate would yield these somebody on the terrorist watch list can go now because we did not close the gun show loophole, could go to a gun show and buy just about anything they want. Is that correct?
They could go through the gun show loophole, or they could go directly to a dealer and buy, because the terrorist watch list status is not one of the screens that disables people from buying a gun. Evidently, we think it's okay for people on the terrorist watch list to be able to buy guns.
Would the senator yield for a question?
So I am not going to call up the amendment, and I look forward to working with my colleagues on the other side and hope that we can make some progress on that before the floor.
Does the senator yield for a question, please?
I don't have an amendment pending at this point, so
Amendment's
Chairman's call. I've
Chairman?
the floor.
The senator like to briefly before we go to the hat.
Chairman, I think there's been a suggestion made that the FBI database that's used to check gun purchases is somehow tied to the terrorist watch list. And I would just ask the senator from Rhode Island or the senator from or the chairman whether, in fact, that's true. It would be news to me. The problem is our background check isn't even tied to people who are adjudicated mentally ill in the states across the country, notwithstanding a 2008 law that we passed. And when there were efforts made to amend that law to provide greater incentives to the states to forward that information to the FBI so people adjudicated mentally ill could be excluded from gun purchases, the majority leader decided to take the bill from the floor and deny us an opportunity to provide it. So I would just ask whether the senator can state as a fact that the terrorist watch list is maintained by the FBI as a means to exclude suspected terrorists from purchasing firearms under current law.
I don't think I followed the question. I think the purpose for the amendment were I to have offered it, which I did not.
Does the FBI background database include terrorist watch list information?
I do not know whether all of it does. I think there's some overlap.
And if it does not,
what this would do is specify that
the senator's argument that somehow,
well, Senator, you asked me to answer your question. I'd appreciate the chance to answer your question if you're going to ask me a question.
Terrorists is not true.
He's trying to answer the question.
You asked me a question. The question is, right now, is the terrorist watch list a stopper for somebody who comes and tries to buy a firearm? And the answer to that, as I understand it, is no, it is not, because the background check does not cross-reference with the terrorist watch list. And so if you are on the terrorist watch list, you can buy a gun in this country. I don't think there's a good reason why somebody who's on the terrorist watch list should be allowed to buy a gun in this country. I'd like to see that fixed, and I look forward to working with my colleagues to try to get us to the point where we can do that.
Before we go further in this, we have, before we finish tonight, and I'll be glad to stay around once we finish these amendments and you can carry on colloquies on matters that are not before us, but we have, here's some of the amendments we have, I know on the Republican side. Grassley, Sessions, Grassley, Sessions, Lee, Grassley, Hatch, Sessions, Lee, Grassley, Hatch, Sessions, Graham, Cornyn, Lee, Cruz, Flake, and on our side, half a dozen amendments. So what I'm going to try to do, tell you what, let's get these done, and then I'll be glad to stay here later this evening, and we can have whatever colloquies we want. And with that, next is Senator Sessions. You were out of the room earlier, and glad to have you back. And because Senator Hatch is not here again, so we'll go to Senator Sessions.
Problem, and it's not gotten better with countries that refuse to take back criminal aliens, unlawful aliens, and I think we all agree that that's unacceptable and it needs to be fixed, but for some reason years and years have gone by, we've not fixed it. Mr. Chairman, I've made some technical corrections to this amendment after it was filed, so I offered a second-degree amendment.
The amendment as amended by the second degree will be, without objection, will be the amendment before the committee. Senator Sessions.
Thank you very much. The Secretary has authority now to discontinue granting visas to nationals of countries that deny or delay accepting their aliens ordered removed from the United States. But this authority has rarely, if ever, been used. Somehow we don't successfully overcome that problem. Because of the Supreme Court's ruling in Zavadas versus Davis and Clark v. Martinez, legal and illegal immigrants ordered removed cannot be detained for more than 6 months where removal would not occur in the reasonably foreseeable future. As a result, in the last 2 years alone, close to 8,000 dangerous criminal aliens ordered removed have been released into the United States. They've been ordered removed from the United States, but they've been released. They do not want to go back to their home country. Maybe they've been in trouble there, and that's one reason they fled their home country.
It looks like folks are going to support it.
Assistant Attorney General Jonathan Kahn testified before the House that because of these decisions and the refusal of countries to repatriate, quote, the government is now required to release numerous rapists, child molesters, murderers, and other dangerous illegal aliens onto our streets. Vicious aliens are now being set free in the United States, close quote. And in 2011, then Executive Associate Director of ICE and Removal Operations, Gary Meade, testified before the House that, quote, some aliens who may have to be released under Zavadas have criminal records that include a wide variety of illegal activity, including but not limited to arson, assault, property damage, extortion, fraud, forgery, homicide, kidnappings, weapon offenses, embezzlement, controlled substances offenses, and sexual offenses. Those aliens detained after a determination that there is no significant likelihood of removal because their home country will not accept them may remain in detention based on a determination that the alien is especially dangerous under specific circumstances. However, he testified countries' refusals or delays have often forced ICE to release the aliens. So these individuals have no right to be in the country. They need to be deported, and countries who participate with us in a entry-exit visa system that works are under a commitment to take back those people we've deported.
Would the Senator yield for a question?
Yes.
I just want to make sure I understand correctly. Under the Zavadas decision by the Supreme Court, if someone who's here illegally commits a crime but then serves whatever the prison sentence or jail sentence is for that crime, once that service, once that time is ended, they can no longer be detained by immigration authorities even though they're illegally in the country and even though they may have been convicted of a crime because their home country won't take them back?
That's essentially it. They can be detained under Zavadas, I guess dicta, but it apparently has been accepted as the law, that they can't be held more than 6 months while we await that country taking them back. Yeah. So if a person completes their sentence for conviction of rape or assault or drug dealing, we set about to deport them back to their home country as the law requires. They just won't take them back. And the Supreme Court said, well, they've served their time. You can't keep them in jail forever. 6 months is all you can keep them, except in very special circumstances. So the problem is these countries are not taking them back, and they should do that. And it's part of the understood international relationship around the world that visas require a country to take back people who are deported. ICE has 24 countries, just to give you some examples, that are a problem. As of December of 2012, China was one of the worst offenders. A great nation like China needs to not be an offender on this. They need to be cooperating. The average time it took China to issue travel documents to accept a return of a person who's been convicted of a crime was 1,010 days, almost 3 years. So the longest delay out of the, they have the longest delays ever.
He's right.
Vietnam has 1,700 outstanding requests to take back convicted Vietnamese nationals. They've averaged 925 days. Jamaica has 1,200 waiting. They've averaged 482 days. And we've issued a démarche to China in 2010 over this subject. They improved just a little bit, but as of July 10th, there's still 1,267 nationals waiting for repatriation. And only Cuba is worse. So, Mr.